Hello everyone. So good evening. Today we are all going to do SOGA, sales of goods acts, and from here and after I am usually going to call it SOGA only, right? Uh, so today is our first class. So we'll have a initial understanding of what is contract of sale, what is sales, and what is agreement to sell. All this. Give me 5 minutes. Okay, the scope of Sales of Goods Act. When we are discussing about sales of good, then the word keyword is your goods. So we need to understand that sales of goods apply only to the goods, and what is good, that is also defined in the act itself. So goods are movable properties. That means it doesn't apply to immovable properties. Okay, and in sale, wherever the Sales of Good Act is silent, there the Indian Contract Act will apply. So anything wherein something is is not specifically mentioned in the Sales of Goods Act, then you have to use that the provision, general provision of Indian Contract Act. And where both of them are silent, then you have to use the custom and usage which is prevalent in that location where they are doing the trade. Okay, so if tell you, like, in the family law, you have read that for the purpose of marriage, uh, rituals are required to be there, right? Similarly, but there are certain custom and uses where there is no rituals. So according to that custom and usage, whatever the performance, their usage, their custom is there, if that is performed, then it will be amount to as marriage. Similarly, for the Sales of Goods Act also, even if there is certain provisions mentioned in the law, but the custom and usage is having certain other no principles or other customs according to which the sales are happening in that locality, and if those custom and uses are reasonable, then in that case it will amount to the sale. Okay, so what do you mean by goods? Goods means every kind of movable property other than actionable claims and money. Can anybody tell me what is exactly money? Who issue money? Is cryptocurrency is a money? Yes. uh, Ananya, who issue money, if anybody can tell me? Yes, RBI. Correct. So cryptocurrency is money, no, right? Because it is not issued by RBI. What is actionable claim? Correct, Ananya. The debt we legally own against someone. Okay. So you are transferring that right to recover that amount, right? So which is not goods and includes stocks, shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. So are these stocks and shares are goods, or are they are it is what exactly this definition is telling? Is this telling that these are all goods or these are not? In order to be goods, what criteria this definition is saying? Are you able to see the same definition, some sort of same definition in the Transfer Property Act and General Clauses Act? What is the exact difference here, which make it goods and which doesn't make the same thing as land? Sachin, आप लोगों ने टीपीए पढ़ा है? जनरल क्लॉजेस एक्ट में आपका इमूवेबल प्रॉपर्टी में डिफिनेशन है ना लैंड का, थिंग्स अटैच्ड टू और फॉर्मिंग पार्ट ऑफ द लैंड.
Yes, ma'am. Exactly, it is.
So what is exactly it is there, right? So what is the exact difference there and here? Because there we are reading the definition of land, right? So land, आपका immovable property में they are including one part is anything which is attached to or forming part of land is also considered as land only, immovable property only, right? Ananya mentioned transfer properties for immovable property. Immovable property includes land, benefit arising out of land, things embedded in earth or fastened to them. Yes, so it is the same thing, na? Things attached to or forming part of the land or things embedded in earth or fastened to them. So what exactly the difference here? We are reading something which is movable, right? Goods must be movable. Every kind of movable property, here the main word it is that goods means every kind of movable property, and transfer property is for immovable property, correct? But there also it is written that things attached to or forming part of the land, or you can say that things embedded in earth or fastened to them, it is same. So what is exactly how there it is saying as immovable property, but here it is mentioning as movable property? What is the exact difference? Is there anything which you are able to see in the definition? In Transfer Property Act, what it says, it does not include growing crops, grass, and timber, standing timbers, right? It doesn't define the immovable property, and the definition is given in the General Clauses Act. In the General Clauses Act, you have it is mentioned that immovable property includes land, benefit arising out of land, and your things attached to a forming part of the land, or you mention things embedded in earth or fastened to earth. So here it is also same, na? Things attached to or forming part of the land. So what it makes different? Anybody? Ananya, will you able to see anything? See, if the keyword is which are agreed to be severed before sale or under the contract of sale. So, if something which is already attached to the earth or forming part of the land, then it is immovable property. But the moment it is agreed to be severed before sale or under the contract of sale, then it becomes movable property. So, if suppose a mango tree is there, so it is it is part of the immovable property only. It is immovable property when it is attached to the earth. Is the mango tree standing timber? Correct. So it is when it is attached to earth, it is immovable property. But the moment it is agreed to be severed before sale or under the contract of sale, it becomes the movable property and becomes good. I hope it is clear. So are these are goods? Fixed deposit receipts, copyright, patent, trademark, stocks and shares, so that is already mentioned in the definition, it is goods. Gas, steam, electricity, will you consider it as a goods or not by applying the definition? This you keep it as a task and let me know. Okay. So when we are saying goods, there are three type of goods. One is your existing goods, second is your future goods, and third is your contingent good. So what do you mean by existing goods? आप लोगों ने पहले सेल्स ऑफ गुड्स एक्ट पढ़ा है और यू आर डूइंग इट फर्स्ट टाइम?
First time, ma'am.
फर्स्ट टाइम, ओके. So okay, then fine. Classification of goods, so it has the law has classified goods into three: existing goods, future goods, and contingent goods. So when we are saying that when we are saying existing goods, means at the time when the buyer is coming to purchase the goods, that good is already existing. And when but however, the law has further classified existing goods into three types, like specific goods. Like suppose one person came to a store and wanted to buy a chair. He specified that I want this chair. Then that is a specific good. It is in deliverable state. The seller has immediately given that chair to the buyer. So the person is buying the specific chair. So it is a specific good. Now, however, specific, ascertain, and unascertain all are existing goods. What key differences are, like when you are specifying a particular article, particular goods, then it becomes specific good. A certain goods is like you cannot particularly suppose if person is saying I need 1 kg rice, so there is a full bag of rice of 10 kg. From that you have to ascertain 1 kg, right? The moment the seller is weighing that and no separating from the 10 kg of no bundle, then that moment he is ascertaining the particular 1 kg. However, that entire 10 kg is existing, right? So it is a sub part of existing goods. However, your seller is asserting 1 kg out of 10 kg. Unascertain good is like the seller is the buyer came and said that I need 1 kg of rice of this particular description has been mentioned. Now it is when the moment he is saying all this, that is unascertained, right? So if you will see, specific, ascertain, and unascertain both are very close to each other. So when the buyer is providing a description of good, it is unascertained because it has to be ascertained from that bag of 10 kg, right? So moment the seller has ascertained it, the particular 1 kg, it become ascertained good, and then he sold it, then it become the specific good. Is it clear or any doubt you have? Okay. So definition says as existing goods means owned or possessed by the seller at the time of sale. Okay. So here the definition in the Barrett, it is mentioned that owned or possessed by the seller. So when I am saying that 10 kg, entire 10 kg, that is in ownership of the your seller. But it might be not owned by the seller. He might be possessing that 10 kg. Is that possible? He might not be the owner, but he's just possessing. So you might have seen that there are many shopkeepers who no उधारी में माल लेके आते हैं, एंड देन जो भी सेल हो जाता है उसको फिर जो भी प्राइस जब उनको रिकवर होता है, देन दे गिव इट टू द एक्चुअल पर्सन फ्रॉम whom they have taken that stuff. Have you seen that thing in the practical world? Yes, Ananya. So you have mentioned, Ananya, he needs to be the owner or have the authority from the owner. So sometime it is not. See, the buyer who is no purchasing that goods, is he going to see the title of the good? Is he seeing, is he going to see कि आप title deed दिखाओ ये rice आपका है या नहीं? So sometime what happened that कि the buyer even doesn't know that कि ये उसका good है या नहीं. सो जैसे स्पॉट ट्रांजेक्शन में जब आप सब्जी लेने जाते हो तो आप उसका टाइटल तो नहीं देख रहे होते हो, या आप कॉन्ट्रैक्ट में तो इंटर नहीं कर रहे होते हो, तो आप स्पॉट ट्रांजेक्शन कर रहे होते हो ना इमीडिएटली. तो ओनरशिप इज डिसाइडेड समटाइम बाय पोजेशन इटसेल्फ. यू आर थिंकिंग दैट कि ओके दैट पर्सन इज पोजेसिंग दैट, सो इट मींस ही इज द ओनर ओनली फॉर द बायर एंगल इफ आई से, राइट? So so in this case what is happening, so owned or possessed by the seller at the time of sale. So he might not be the owner, but he is possessing that and he is transferring that to the buyer. So that's why the bona fide buyer concept is that the person who has bought the stuff in good faith, then his ownership will not be again challenged because he has bought it in good faith. Correct. So uh, that is why, because of the word possessed. Sometime even if that person is not having the authority from to sell, but the person who has bought it has bought in good faith. Okay, so this is how the word possession has relevance. Specific good identified or agreed upon at the time of sale. So I have given you example of chair, so that has been particularly identified and agreed upon. Ascertained goods become ascertained subsequent to the formation of contract of sale. So the moment the contract of sale happened, like he mentioned that I need 1 kg of rice, and then post the contract of sale, the seller has no segregated that 1 kg from the 10 kg of bag. Then it becomes ascertained. Unascertained good defined only by description and may form part of a lot. So it is just before that formation of contract of sales. So like the person has given the description, that moment it is uncertain. The moment the seller has no segregated that according to the description, then it becomes ascertained. And when he hand it over after weighing that particular ascertained good, then it becomes specific. Okay, so Uh, Ananya, the specific goods and unascertained goods are similar. No, it is not similar. It's like stages. The first stage is unascertained good. Second stage is ascertained good, and third is specific. In a way, ascertained and specific are very thin line difference, and sometimes it is very difficult to say there is any difference. Okay, but definitely unascertained and specific has difference, because when you are handing over the 1 kg good, the moment it is no specified that this is the particular which the buyer is buying, then it is a specific good. But when the buyer is just describing it, that I need 1 kg of basmati, and you are from that you have 10 kg of 10 different packets of basmati rice, but you just but that is an unascertained stage, right? You just the buyer has just mentioned only the description that I need, you have might be having 10 different kind of basmati. So he has given you a description of that what kind of basmati he is looking for. So that time it is unascertained goods. And when you are according to that description, when you are segregating from that lot, then it become ascertained good. So in a way it's ascertained and specific are just theoretical difference, but practically it is very difficult to say that what is specific and what is ascertained good. Okay, so delivery. So these are general definition we are going through. Post that we will go through the through your Bear Act. So delivery. What do you mean by delivery? Uh, layman, as a layman language, what you will understand from delivery?
Ma'am, to deliver the possession of goods from one person to another.
हाँ, आप किसी चीज का पोजीशन ट्रांसफर करते हो एक पर्सन दूसरे पर्सन के पास पोजीशन ट्रांसफर कर रहा होता है तो उसको डिलीवरी बोलते हैं, राइट? आप
Yes, ma'am.
हाँ, तो इसमें क्या हो सकता है कि आप एक फिजिकली पूरा इंटायर गुड्स ट्रांसफर, गुड्स का पोजीशन ट्रांसफर कर रहे हो वन फ्रॉम वन पर्सन टू अनदर, देन इट्स बिकम एक्चुअल डिलीवरी. What is constructive and symbolic? This is very important. Many people are very much confused about difference of constructive and symbolic. तो अगर आप सपोज एक की दिए, आपने सपोज एक अपने नो घर का की किसी को देते हैं, तो वो जब आप की दे देते हैं तो उसको बोलते हैं आप क्या, अब बिकॉज ही इज हैविंग द की ऑफ दैट फ्लैट, so he is able to only open that door of the flat, so he is having, that is a symbolic delivery. Nobody else can enter into that house, correct? So similarly for any of the goods also, like car. So if you're handing over the key of the car, so you are that is a token, that's how the token, the transfer through a token. So it is a symbolic delivery. But constructive delivery में क्या होता है ना, कि suppose you if suppose suppose I am having a warehouse wherein I have kept your uh, five different kind of 50 kg of rice in that, five different kind of 50 kg of rice in that warehouse. Now Ananya, you came and you wanted to buy that 50 kg of rice, five different kind of 50 kg of rice. So you came and you have inspected that rice, and now instead of no since I own that, mm, I am having the no I own that 50 kg rice in that warehouse. So the warehouse person who is looking after the warehouse, the caretaker of the warehouse, I just, when I have you has inspected and you have told that कि, okay, I'm willing to buy that, and you bought that entire no rice, 50 kg of rice from that warehouse. So you have not taken the exact entire delivery. Now the caretaker is possessing that entire stuff on behalf of you. Okay, so this is your constructive delivery. Earlier the caretaker of the warehouse is holding on my behalf, now it is holding all the goods on your behalf. Only the owner has changed, but the physical state of the goods has not been changed. So this is called constructive delivery. So when a person in possession of the goods belonging to the seller acknowledges to the buyer that he holds the goods on buyer's behalf. So earlier he was saying, earlier the caretakers, whenever if anybody came and asked the caretaker from whom for on whose behalf you are holding, earlier he would have called my name, now he would have called your name. That's the only difference in the constructive delivery. Okay. Contract of sale. A contract of sale in goods, a contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So will you able to see anything in this? There is two things mentioned. One is your contract whereby the seller transfers. In first, before or it is mentioned that where the transfer is happening, and the second part says that agrees to transfer the property in goods to the buyer for a price. So it contract of sales include two things. One is your sales, when the first part when says contract whereby the seller transfers. So this is saying about the sale, and the second part agrees to transfer the property in goods to the buyer. That is your agreement to sell. And what this the sale or the agreement to sell must be for a price. So if there is no price, then there is no sale. There is no contract of sale. Okay, there may be a contract of sale between one part owner and another. So you have to it is again a task which I will provide, which I wanted to understand from you, that what exactly this line want to say. Okay, keep it as a task. Hence contract of sale includes the definition of sale as well as agreement to sell. From the from the definition you can understand. Okay, wherein contract of sale, the property in good is transferred from seller to the buyer immediately. The first part says whereby the seller transfers. So it says that when the transfer is immediate, then it is sale. But when it is no agrees to transfer the property in future date, or no upon completion of certain condition, then it is agreement to sell. Okay, the same has been defined in the section 4 subsection 3 of the SOGA. So you can see here, there is an absolute. The definition includes two things. One is your absolute sale, and another is your conditional sale. So the first part, contract whereby the seller transfers immediately, that is absolute sale, and the second part says about conditional sale. Okay, see, the definition says that it is intending to transfer at a future date upon completion of certain condition thereon. Okay. Thus, whether contract of sale of good is an absolute sale or agreement to sale depends on the fact whether it contemplates immediate transfer from seller to buyer or the transfer is to take place at a future date. So, example says S agrees with Y on 10th April 2025 that he will sell his car to Y on 10th May 2025 for a sum of 8 lakhs. Is it sale or agreement to sell?
Ma'am, agreement.
Correct, because it has to be done on future date. However, if there is certain condition attached that okay, like it will be it will be sold only when no, you will give your daughter on marriage. Anything like that condition is also attached. Then also, if on the completion of promise, that again uh, be possible. It is not necessary only for the time elapse. Okay, so in this definition, you have seen this word transfer the property in goods. So what do you mean by property?
Ma'am, movable property.
ठीक है मतलब वो that is about goods, but when I am saying about no property in movable, see, this that's not actually what I'm trying to say. When the if you will say that property, what do you mean by property? You might say that okay, movable, immovable, or tangible, intangible, right? That is but the definition is saying about from in case of movable property also, there is a transfer of property of movable good. If I can say transfer the property in movable good. Okay, so what exactly the property in that there it means? Because when we are saying, see if you can see that what Ananya you were saying, goods means itself is a movable goods. Every kind of movable good is called goods, right?
Yes, ma'am.
So here the definition doesn't want to say that, law doesn't want to say that it is movable property. It is about some characteristics in the good, which is about we are discussing about that transfer the property in goods. So uh, ownership, how you decide that there is an ownership. Suppose if I have a particular ring with me, okay, and that is I just possess it. I have the possessionary right because Ananya, you hand it over to me for no for certain period of time. But who is the owner? You are the owner. So currently, I have this. No, what if I want to no sell it? I will not able to sell it to somebody else because I am not the owner. I have just possessionary right. So this is one property. But being you as an owner, you have multiple rights over that gold ring. You can sell it, you can dispose it, you can use it, you can throw it, right? You can destroy it, you can put it in
Yes,
place.
ma'am.
So these are properties. So when we are saying transfer agrees to transfer the property in goods, so what exactly the what
Ma'am, we
kind of
are
property?
having the title of the goods. We are having the title to the goods.
Correct. So here, see, sometime what happened when you are seeing in the when I have given you one example wherein the person is not the owner, he has taken some no something from another owner, from another person who is the owner, and he has mentioned that, okay, I will pay you only when I will get it, I will sell it. Okay, so if he will not able to sell it, he will return it to the owner, actual owner. So he becomes the owner only when he will sell it. Otherwise, he just possessing that on behalf of the actual owner. Correct.
Yes, ma'am.
So even there are many a situation wherein the goods is in the hand of somebody else. Like when you are placing that gold ring to me, so I am having the possession because you have taken a debt from me, and on that debt you have kept it as a security. But you, being the owner, you still can sell that gold ring to any other person, or will you not? आप बेच सकते हो ना वो गोल्ड रिंग किसी को भी.
Yes, ma'am.
हाँ. So when I'm saying that transfer the property in goods to the buyer, here which kind of property it is the law wants to tell? It is saying about the general property, that the ownership. But what I am holding, uh, because you have given me on place, that's why I have just a possession right over that. If you will pay that debt, then I will not have that right over it. But if you will not pay me, then I have right to sell. Otherwise that right will not come to me. So I have special right over that property. But you have the general right. You can sell it to any person whenever you want it. Okay. So general property in a thing transferred subject to the special property continuing to remain with another person. I hope it is clear. So this is a similar example. If A owns certain goods, places them to B, A has general property in the goods, whereas B has special property or interest in goods to the extent of the amount of advance he has made. In case A fails to repay the amount borrowed on placing the goods, then B may sell his goods but not otherwise. Okay, so sales of good, whenever there is a transfer of property, it is when the sale is happening only when there is a transfer of property. And when we are saying about transfer of property, that means general property. Okay, let me go through the from Bayer Act. Okay. So we have discussed most of the thing here. Buyer means a person who buys or agrees to buy goods. Delivery means voluntary transfer of possession from one person to another. Here it is not saying about the ownership, okay? It is saying about the possession. So ownership might be transferred later on also. Delivery may be possible that it will first happen the delivery and the ownership will happen later on. Okay. Goods are said to be in deliverable state when they are in such state that the buyer would under the contract be bound to take delivery of them. So before suppose in case of uncertain good, it cannot the delivery cannot be possible, right? Because it is not in a deliverable state. Future goods. So future goods means good to be manufactured or produced or acquired by the seller after the making of the contract of sales. So mostly what in case of future goods, sorry. So is it possible to have a no? Uh, will you consider it as sale or agreement to sell?
Ma'am, agreement to sale.
Yes, because at the time of contract of sale, the goods itself is not existing. So it will happen only when the sale will be possible only when the goods will be in a deliverable state. Okay. Goods means every kind of movable property. This we have already read. Okay. Price means money consideration for sales of goods. So very important. If there is a suppose if Mr. A says that ki, I want to buy 1 kg of rice, and on behalf of that I will give you a pair of shoes. Is that possible? Is it a valid sale?
Ma'am, can you please repeat?
So suppose if Ananya, you want to buy a 1 kg of rice, and you said to the shopkeeper that I will give you a pair of shoes, and on that you will transfer me 1 kg of rice. Is it a valid sale?
No, ma'am. The consideration here has to be a price.
Yes, yes, and that must be a money consideration for sales of good. It can't be kind. Okay. So another is your property. Property means the general property in goods and not merely a special property. This we have already discussed. Seller means a person who sells or agrees to sales goods. Specific goods means goods identified and agreed upon at the time of a contract of sale is made. सो स्पेसिफिक गुड्स के केस में भी ना ऐसा हो सकता है कि आपका एग्रीमेंट टू सेल भी हो सकेगा, है ना? कि ऐसा नहीं है कि आपको इमीडिएटली आपको वो गुड्स देना है। आप बोल सकते हैं कि आप जो है फलाना फलाना डेट में आप मुझे वो यही स्पेसिफिक पर्टिकुलर गुड्स आप मुझे दीजिए। इन दैट केस ऑल्सो, बट इट द की वर्ड इज आइडेंटिफाइड एंड एग्रीड अपॉन। ओके। Sale and agreement to sell, this is the exact we have discussed, wherein the contract of sale may be absolute or conditional. Absolute कब होगा? In case of sale, but conditional कब होगा? आपका agreement to sale के केस में। Okay. Contract of sale how made? A contract of sale is made by an offer to buy or sell goods for a price and the acceptance of such offer. इट्स अ जनरल डेफिनेशन विच वी हैव ऑलरेडी रेड दैट कि कोई भी चीज हो नहीं सकता ना, कोई कॉन्ट्रैक्ट पॉसिबल नहीं है जब तक आप उसको एक्सेप्ट नहीं कर रहे हो। तो देर मस्ट बी ऑफर, एक्सेप्टेंस एंड कंसिडरेशन। दिस इज व्हाट एग्जैक्टली इट इज सेइंग। द कॉन्ट्रैक्ट में प्रोवाइड फॉर द इमीडिएट डिलीवरी ऑफ द गुड और इमीडिएट पेमेंट ऑफ द प्राइस और बोथ। सी दिस इज व्हाट, आप डिलीवरी पहले कर सकते हो और आप पेमेंट और जो है पेमेंट आप लेटर ऑन पीरियड में कर सकते हो, या फिर आप डिलीवरी जो है आप लेटर ऑन पीरियड में कर रहे हो और पेमेंट आप पहले कर रहे हो, और या फिर आपका दोनों चीज ऐसा भी हो सकता है कि आप डिलीवरी और पेमेंट दोनों एक साथ कर रहे हो। मतलब आपने गुड्स भी ले लिया और पेमेंट भी इमीडिएट दे दिया, ऑन स्पॉट ट्रांजेक्शन, राइट? और या फिर आप डिलीवरी और पेमेंट दोनों ही आप पोस्टपोन कर रहे हो। तो ये ऑल दिस थ्री कैन बी पॉसिबल और दिस अल्टरनेटिव कैन बी पॉसिबल। ओके। or for delivery or payment by installment, or that the delivery or payment or both shall be postponed. Okay. Subject to the provision of any law for the time being in force, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties. So this is what, like, many a time that buyer just pick up the stuff and then went, because it is habitual. The seller has this kind of relation between the buyer and with the buyer, and he will just note down, okay, the person has taken this stuff, and he will just note down in the diary. So this is how on the basis of conduct the sales is happening. Existing or future goods. The same definition is there. Good perishing before making of contract. Okay. Where there is a contract for the sale of specific good, the contract is void if the goods without the knowledge of the seller have at the time when the contract was made perished or become so damaged as no longer to answer to their description in the contract. So this we have read now, like suppose before the making of the contract itself the goods is not there, In case of impossibility also, we have read that after the contract is made, and then it is difficult to perform it because the subject matter itself is not existing, then it becomes void contract, correct? But if before the contract take place, before that, if the subject matter is not there, then it is void of an issue, because the good itself is not there. Good perishing before sale but after agreement to sale. So where there is an agreement to sell specific goods, and subsequently the goods without any fault on the part of the seller or buyer perish or become so damaged as no longer to answer to their description in the agreement, before the risk passes to the buyer, the agreement is thereby avoided. The same in case of void contract. Okay, how the ascertainment of price happen in case of in case of sale, contract of sale. So the price in contract of sale may be fixed by the contract or may be left to be no fixed in the manner thereby agreed, or may be determined by the course of dealing between the parties. So what it exactly saying, कि आप जो है आपने जब आपका कॉन्ट्रैक्ट ऑफ सेल आप जब हो रहा है, आपने उसी समय आपने बता दिया कि ये प्राइस है, ठीक है? तो at the time of contract itself you have fixed the price, or may be left to be fixed in a manner thereby agreed or may be determined in the course of dealing. So sometime what happened that the price is depending, suppose आपने टर्म्स ऑफ कॉन्ट्रैक्ट में आपने मेंशन कर दिया कि आप जो है वैल्यूअर जो है आपका प्राइस डिसाइड करेगा कि इस गुड्स का प्राइस कितना होना चाहिए. सो यू हैव लेफ्ट इट टू बी फिक्स्ड in certain manner, right? And what the manner is that the valuer will decide the price. So this is agreed upon, that manner has been agreed upon, or may be determined by the course of dealing. और या फिर आपने जो है कोई मैनर नहीं स्पेसिफाई किया है, you just left it for certain no, in the course of dealing you that will be determined. That ki suppose you have decided that कि, okay, the in the market, if the price according to the price in the market, the price will be having certain suppose the price will be 100 in the market, then I will be buying at lesser than 10 rupees from whatever it is prevailing in the market. So during the course of dealing you are might be determining that price, so it will be up and down happening according to the market. Where the price is not determined in accordance with the foregoing provision, the buyer shall pay the seller a reasonable price. What is reasonable price is a question of fact dependent upon the circumstances of each particular case. Okay. Anybody has question?
No, ma'am.
Okay. Can anybody able to tell me whether software is a good or not? आप लोग अपने डेली लाइफ में बहुत बार सॉफ्टवेयर यूज कर रहे होते हैं ना?
Yes, ma'am. Their softwares are goods.
So at what moment you will decide that sale happened? If we'll read the definition of sale, सेल होने के लिए डिलीवरी होना होता है. सो व्हेन यू आर डिसाइडिंग, कैसे आप डिसाइड करते हैं सॉफ्टवेयर में डिलीवरी हुआ?
मैम जब हमको एक्सेस मिलता है या फिर हम उसको यूज करते हैं.
ओके. एनीबडी एल्स हैज डिफरेंट आंसर? सॉफ्टवेयर के केस में क्या होता है कि आपको आपको एक्चुअल डिलीवरी कैसे पता चल रहा है? आप यू आर सेइंग दैट कि व्हेन यू रिसीव दैट लाइसेंस टू यूज, राइट?
Yes, ma'am.
So that time you were saying that delivery happened. बट एवरी टाइम जब अपडेट आ रहा होता है, सॉफ्टवेयर में अपडेट्स भी आता है.
हाँ मैम.
So if that if suppose if you have not updated that software, when you got a no update notice that ki updation aaya hai and you have not updated, and because of that there is some glitch happened for which whatever purpose you have taken that software, and so because of that whatever the no work you are doing, it has been spoiled. Say if you are computing some ITR returns, or if you are doing any kind of work from software, and you have not updated it, because of that whatever you have done, there is a lot of error. Now who will be responsible on that? Who is the owner of that software?
Ma'am, since the
Because
update
sales
was
के लिए हमें क्या होता है, ट्रांसफर ऑफ प्रॉपर्टी.
released and it was on
Yes,
our
Ananya.
end that we did not update our software.
Hmm. So risk is with you only.
Yes, ma'am.
Okay. Will you able to research further on this, Ananya?
Okay, ma'am.
Okay. So we have discussed till your ascertainment of price, I think. Yes. Agreement to sell at valuation. This also we have discussed, right? One of the manner is there. If suppose in this what why there is a separate section. So basically it is saying that in the where there is an agreement to sell goods on the term, the price is to be fixed by the valuation of a third party, and such third party cannot or does not make such valuation, the agreement is thereby avoided. So suppose if you have mentioned in the terms that third party will do the valuation, and if that third party will have not done that valuation, then you might avoid that contract itself, or you can also have an option that okay, I've instead of avoiding, you can change the third party itself, right? So it has option that you can avoid or you cannot, provided that if the goods or any part thereof have been delivered to and appropriated by the buyer, he shall pay a reasonable price. Therefore, yeah, this is based upon the unjust enrichment. Suppose if the buyer has already consumed certain part of that goods, then he must pay for that portion. When such third party is prevented from making the valuation by the fault of the seller or buyer, the party not in fault may maintain a suit for damages against the party in fault. This we have already read also in the Contract Act, where we are discussing about the performance of contract. That the party who is no restricting the other party for performing, then the party who is in fault has to pay damages. Okay. Before condition and warranties, let's discuss certain other provisions. Okay. So we are left with two differences: sale versus agreement to sell. In case of agreement to sell, this is the general differences. I hope everybody will be understanding now. Transfer of property. इसके सेल के केस में क्या हो रहा है, आपका प्रॉपर्टी इंटायरली ट्रांसफर हो जा रहा है, गुड्स जनरल प्रॉपर्टी. व्हेन वी आर सेइंग अबाउट प्रॉपर्टी, दैट मींस जनरल प्रॉपर्टी. ओके. सो प्रॉपर्टी इन द गुड्स passes to the buyer. In case of agreement to sell, the property in the goods passes to the buyer on future date or fulfillment of condition. It is not transferring immediately. So this is the very foundational difference between sale and agreement to sale. Nature of contract. It is executed and it is executory in ATS. What do you mean by executory? हमने कॉन्ट्रैक्ट एक्ट में पढ़ा था क्या, एग्जीक्यूटेड कॉन्ट्रैक्ट एंड एग्जीक्यूटरी कॉन्ट्रैक्ट, यूनिलेटरल बायलेटरल, ये सब डिस्कस किया था क्या हमने?
मैम यूनिलैटरल बायलैटरल नहीं किया था।
ओके, सो बायलेटरल का मतलब ये जब आपका दोनों की तरफ से पेंडिंग। एग्जीक्यूटरी कॉन्ट्रैक्ट में क्या होता है ना, दो तरीके से आपका एग्जीक्यूटरी हो सकता है, एक यूनिलेटरल हो सकता है, एक बायलेटरल हो सकता है। यूनिलेटरल में वन पर्सन हैज परफॉर्म हिज पार्ट एंड द अदर पर्सन इज पेंडिंग, एंड द बायलेटरल में बोथ द पार्टीज has not performed his part. So we have just discussed that the possibility will be that the goods has delivered, and suppose the seller has delivered the good, but the buyer has not paid the price, so it is executory, and this is unilateral in unilateral, because one person has performed his part, but the other person has not performed his part, right? And when both the delivery and the payment of price both is pending, in that case bilateral, both party has not performed his part, so it is bilateral. So in case of agreement to sell, it might be a unilateral or bilateral executory contract. Okay. Remedies for breach. Remedies for breach, in case of sale, the seller can sue the buyer for the price of the goods because of the passing of the property therein to the buyer. So since the goods the property has already been transferred to the buyer, so the only liability of buyer is to pay the price. So seller can only sue the buyer only for the purpose of for recovering that price. He cannot recover the goods, right? But in case of agreement to sell, the aggrieved party can sue for damages only because the goods is already with him. He's, or if the good is not with him also, no, he can, the ownership is still with him. So he can only no sue for the damages, not for the goods, because ownership is still with the person. Liabilities of parties. A subsequent loss or destruction of good is the liability of the buyer. Since the property has been transferred to the buyer, so along with the ownership, the risk also transferred. And because the risk has been transferred, any kind of loss or destruction happened to the good, it is the liability of the buyer and not of the seller. But in case of agreement to sell, since the ownership is still with the seller, so any kind of loss or destruction happened, so it is the liability of the seller. Burden of risk. Risk of loss is that of buyer since risk follows ownership. I think this is self-explanatory.
Yes, ma'am.
Nature of rights. So in case of sales, the right is just in rem. What do you mean by just in rem? We have already discussed in Indian Contract Act.
Ma'am, it means right against the world.
Yes.
Ma'am,
So
so it
आप
means it can be enforced against anyone.
करेक्ट एनीवेज बोथ इज फाइन ओनली बिकॉज दैट मीन्स कि आपने जो पर्टिकुलर गोल्ड रिंग आपने शॉपकीपर से खरीदा है वो आपका है. Nobody else in the entire world can ask no has any say over it, right? So it is, that means it has the right is just in name. But in case of agreement to sell, it is just in personam because the ownership has not been transferred. So it is this right is no is between the seller and the buyer only. The seller has to whatever the seller has agreed to sell to you on fulfillment of certain condition which you have to fulfill. This entire contract is between you and the seller. So there is the right which is just in personam here because it is between you and the seller. Right of resale. seller cannot resell the goods because the ownership is already transferred to the buyer. He cannot right now sell that good, right? Even if that good has not been delivered. Suppose, Ananya, you have not taken the delivery, but you have taken, you have paid the price, and and the ownership has been already transferred to you, but the seller is only holding that good on your, on behalf of you. Still that seller cannot resell that good because you are the owner. But in case of agreement to sell, the ownership has not been transferred, so in that case he can resell that. In case of insolvency of seller, suppose the seller is insolvent. In that case, the official assignee in case of sale have only say over the price, only right of the, only take over the price that which is recoverable from the buyer, but he cannot able to take over the goods. In case suppose seller, suppose if you are insolvent, in that case uh, the official and assignee will take over all your properties. So if you have not no, if the buyer has not paid the price of that good, then he has that official and assignee has right to take over that right to recover that price from the buyer. But the buyer has already paid the price, then in that case official assignee will not have any say on that. But in both the situation, whether he has not paid the price or paid the price, the official assignee has no right over the goods. But in case of agreement to sell, the official assignee will acquire control over the goods because the ownership has not been transferred. In case of insolvency of buyer, so if the buyer is insolvent, then the official assignee will have control over the goods, whether the buyer has paid the price or not paid the price. Okay. But in case of agreement to sell, the official assignee will not have control over the goods. Suppose if the no you have the good, the buyer has not no has taken the goods, but there is certain condition which has to be yet to be fulfilled in order to order to transfer the ownership. Then in that case also the official assignee will not have control over the goods because ownership is not with the buyer. Any query? Okay, shall we move to sale versus hire purchase? Okay, so what do you mean by hire purchase?
Ma'am, it is like someone taking a good on EMI or installment payment.
Yes. So हायर परचेज एग्रीमेंट में क्या होता है कि हाँ द सेम वेज कि somebody has given a goods are let on hire and under which the hirer has an option to purchase them in accordance with the terms of the agreement and includes an agreement. It is not necessary that कि the owner in see installment में आप purchase कर रहे होते हो. Sometime also happen that कि somebody is no taking some goods on hire and if that person has paid the amount, then then in that case the ownership will also be transferred. But if the entire amount has not been no paid, then in that case he just using that and then hand it over back to the return it back to the person from whom he has taken that good. So in case of what you have said, Ananya, it is completely correct. So in case of hire purchase, property is transferred upon the last payment of installment. Most of the cases we have seen in the car wherein a person has purchased in EMI, and sometime also a person just takes certain goods on hires and paying the higher prices. But if once the person no just return it, then and has not paid the entire amount, the last installment, then the property has not transferred to him. In case of sale, the property transferred immediately. So the position of the party in this case, in case of sale, buyer is equal to owner, but in case of hirer, the person who is taken the property on hire, then his position is like bailee. So until he pays the last installment, he just uh, possessing that goods on behalf of that biller, like for the certain use. So in case of he has no taken out for certain purpose or for certain use, that time also he is considered as taken as on hire, right? Termination of contract. So buyer can't terminate, has to pay the entire price. But in case of hire purchase, hirer can terminate by returning the goods. Burden of risk of insolvency of the buyer. So in case of sale, seller takes the risk of loss resulting from the insolvency of buyer. But in case of hire purchase, the owner does not take any kind of no. The owner has entire risk. He in case the buyer is insolvent, just the owner can take back the good. Uh, the buyer. I think I have written it wrongly here. The owner takes no such risk. He can take back the good. Okay. Yes. So in case of the insolvency of buyer, the risk of losing that uh, price is not there. He just take back that good from the hirer. Okay. Transfer of title. In case of sale, the buyer has the good title, so he can sell it to any person whom he want. But in case of hire purchase, the hirer cannot pass any title because he does not have that title, right? So even if the hirer has sold that to anybody who has taken it in good faith, but still the ownership is not, he will not able to pass on that ownership to the bona fide purchaser because he does not have that ownership. जिसके पास जो चीज है ही नहीं वो उसको ट्रांसफर कर नहीं सकता ना. So in case of hire purchase, hirer cannot pass any title even to a bona fide purchaser until he pays the last installment. Sale versus bailment. So in case of transfer of property, okay, I'll not like to share this screen. I hope most of you understand what is sale and what is bailment. Will you able to tell me differences between sale versus sale and bailment?
Ma'am, sale is where we are buying and selling a good, whereas in bailment we are only giving the temporary possession to someone, and when the work is done, we take it back.
Yes. So for any reason, might be it is gratuitous, non-gratuitous, कोई specific purpose के लिए and all those, and even sometime you will not take it back. You will ask him to dispose it off. But what is happening here in case of bailment? You are not transferring the property, general property. You are just transferring the special property. That's the key difference. Right, because in bailment also you are not taking there might be a situation where you are not taking back that good. You might will ask that person bailee that you dispose it according to your direction, but he is just possessing that goods for certain purpose, right? Or for any reasons, like in case of gratuitous it is might be for just use. So the only the thing which is transferring is the possession of that good to the bailee. So it is a special property which is transferred in the bailee, special property which is getting transferred in case of bailment. But in case of sale, your the general property itself is getting transferred. Any other point, any other differences which anybody can see between these two? So in case of sale, you will not able to, in any of the scenario, will not able to ask for return of good, right? Because it is already the ownership has been passed. You will not now later after the sale you will not able to ask him to return the goods to you. But in case of bailment, you might ask for the return or you might ask for the no disposal.
Ma'am,
And
another difference we can say that in sale we are having a consideration which is mandatory, money price, whereas in bailment there may be or may not be any consideration for one part.
Correct, correct, very correct. So this is the three differences mainly between the sale versus bailment. And I think in the previous questions, OJS questions, we have seen all this type of question also: sale versus hire purchase, sale versus bailment, and your sale versus agreement to sale. I think now it is, and what is sale and what is agreement to sale, and also the delivery. So when if what is delivery and types of delivery. So I hope all these questions now you are able to answer. Okay, so we'll discuss from Bear Act. So we'll start with this stipulation as to time. Okay, so what is conditions and what is warranties? I think it is an entire new topic. Before everything we have discussed, 11, 12 will be a completely new topic implied as to title. Sale by description. Okay, these are also the part of this condition and warranties. Okay, so we will do this in the next class. Now your transfer of property is between seller and buyer. I think we have discussed this part. Good must be ascertained. Property passes when intended to pass. Okay, so this is very important, I think. Where there is a contract for sale of unascertained good, no property in the good is transferred to the buyer unless and until the goods are ascertained. This we have already discussed, right? Property passes when intended to pass. Where there is a contract for the sale of specific or ascertained good, the property in them is transferred to the buyer at such time as the party to the contract intend it to be transferred. What do you mean by intention here? Why the intention is very much important? Just as a layman, you can say.
Ma'am, there may be a case where a person is showing his goods that these are the options available, and from that he has not specified which good has to be taken. So, with the intention, he is telling that only this portion of the goods can be ascertained.
Okay. See, uh, 1 minute. So it says that property passes. So when we are saying the general property, okay, so it passes only when it intend to be transferred. So intent to be transferred means like it talks about कि delivery कब हो रहा है, right? डिलीवरी आपकी प्रॉपर्टी की कब हो रही है, जब वो इंटेंट कर रहा है ट्रांसफर होने का. So again, how the intention will be decided? For the purpose of ascertaining the intention, it is given in the 19 subsection 2. Okay, how the intention is decided? For the purpose of ascertaining the intention of the parties, regard shall be had to be the terms of the contract, the conduct of the parties, and the circumstances of the case. So there is three ways wherein you will determine whether there is an intention to transfer is there or not. Okay, these three ways. So in case of terms of contract, so if in the terms of contract itself it says that ki, the moment I will hand it over the document of the goods to you, it amounts to delivery. So when you have given the document to the buyer, even if that good is in your showroom itself, then also you have intended to transfer it. I mean the property transferred to that person, because in the terms of contract you have mentioned that when I will hand it over the document of the movable goods, then the property passes to you. So you're intending it to be transferred when it is when just the document will be handed over to the buyer, right? According to the terms of contract. In case of many of the contract, you have seen that document टाइटल जो होती है आपकी, या फिर कोई और मतलब देयर आर मेनी थिंग लाइक बिल ऑफ लेडिंग और समथिंग. So even if the goods is some other place, but if just handing over the bill of lading, it amounts that ownership has been transferred. Correct. Secondly is your conduct of the parties. So if you have decided that ki, uh, you just you have just suppose you have given the buyer has provided one bag to the seller, that you just wrap this good in my bag. So the moment you have wrapped in his bag, and you have taken the price, from that conduct itself the property passes to the buyer, right? Or any circumstances of the case, it's again depending upon the facts and circumstances. Like it's a reasonable man test. Again, this is an objective test, because might be in particular locality the transactions happen into a particular way, and according to that circumstances, according to the circumstances, say suppose the person is sick, and you just handed over the no the medical some medicine, and you are just standing in front of him, and you just given that medicine to that person, and you both have a knowledge that this handover is not free of cost. Then also the delivery happened, and he will later on pay you the price. So according to the circumstances of the cases also, the delivery might be possible. Okay, unless a different intention appears, the rule contained in section 20 to 24 are rules for ascertaining the intention of the parties as to the time at which the property in the good is to pass to the buyer. So uh, this we have already read, like specific good in a deliverable state, specific goods to be put into a deliverable state, specific goods in a deliverable state when the seller has to do anything thereto in order to ascertain the price, sale of unascertained good, and appropriation. I think this is suppose nothing is specified in the term and condition, then according to this you have to decide how the delivery will be happening. Okay, so this you will read it, and rest of the part we will do it in our next class. Any queries? आप लोग प्रीवियस ईयर के क्वेश्चंस देख के आ सकते हैं कल. So if any questions we have not covered, we will take it as in that class itself. Okay, so let's end our class. Thank you all. Good night.
Thank you, ma'am.